So we are going to go ahead and get started. I want to go ahead and address a few housekeeping issues. First, every CDFA who attends this webinar will receive 1 hour of CE credit. The credit will be placed in your account within the next 2 weeks. We'll also be sending a recording of the webinar in a follow-up email tomorrow, along with any materials that Jackie is sharing with us, so be sure to watch out for those. And then lastly, if you have any questions during the webinar, please enter them into the chat box of your GoToWebinar menu. We will get to as many as we can during the presentation, so the last like 10 minutes or so, and you will get Jackie's contact information at the end of the webinar for any other questions you may have. And I'll also send her any additional questions that we do not get to in that Q&A section at the end. And finally, a little bit about Jackie. She is the former Executive Vice President of IDFA and has been in private practice for over 20 years as a divorce financial planner, lecturer, blogger, and software developer. She co-owns Divorce Solutions, LLC, a Michigan-based company that prepares over 1,000 quadros per year for Michigan attorneys and provides divorce financial planning services. Her work with divorcing clients has been featured on an episode of Kiplinger's Personal Finance television show, The Investment News, Bloomberg's Wealth Manager, Fortune, and most recently Money Magazine. She has also published numerous articles in the Michigan Family Law Journal and Michigan Lawyers Weekly, and writes a biweekly blog for her website, divorcesolutionsllc.com. In addition, she's lectured all over the country on divorce financial planning and quadro issues for bar associations and professional financial groups. Her latest venture is the newly launched company, Divorce Access, which specializes in quadro drafting services via financial professionals across the country and incorporates the proprietary quadro drafting and practice management software developed by Jackie herself. Now let's turn it over to Jackie.
Hi, everyone. So the first question is, why are we all here? Why do CDFAs need to be fluent in this topic? We're not going to be drafting the orders that divide up military or civil service plans, so can't we just turn that over to someone else? As you all know, military and civil service plans are exempt from ERISA, and therefore they're exempt from all the quadro provisions, but they are subject to division under federal statutes. Now, since I first started presenting on this information, the basics, loopholes, and traps have changed dramatically. In fact, opposite from quadro rules, which have only had some minor recommended changes by the Department of Labor, the rules concerning federal employees' pensions are constantly in a state of flux. So there's no denying that this is a complicated topic, but your client expects you to be the expert if you're involved in their case and they are a civil service or military member. And guess who they're going to blame if you didn't warn them about something like if they got remarried, they might lose the entire share of their former spouse's pension. Now, no one expects you to remember all the rules. Obviously, there's an opportunity for you to work with clients during the divorce to advise attorneys and advise the client. And keep in mind always that there's no putting the toothpaste back in the tube once it's been agreed to. And then, of course, there's the opportunity to work with clients post-divorce. Number one, trying to put the toothpaste that you can't put back in the tube, and also helping them anticipate any gaps, loopholes, and traps with their settlement agreements once they've been finalized, and trying to help them that way. So no one expects you, again, to remember all the rules and keep up with all the changes. However, there are some things that you really should know. The most important is to remember that there are a surprising amount of rules, and they change all the time. You and your client need to tread very carefully. The other things I believe you really need to have easy access to in your brain, well, when we come to these points in the presentation, I'll let you know this is something that in particular that you want to remember. So grab your coffee and let's begin. So we're going to be covering two basic topics today: civil service employees, pension plans, military members' pension plans, and we are as we go through, we are going to be comparing and contrasting those plans with corporate pension plans. So there's going to be a lot of information in here. And I think the easiest way for you to remember that there's something that you need to remember about civil service and military plan division is if you can get in your mind it locked in that there are some key differences between ERISA plans. And so we will be going over that. And then I'm also going to be covering some important tips for divorce financial advisors to make sure that when you're working with clients that you look really good. Okay, so let's begin with civil service employees. So who is a civil service employee? Those would be postal workers, people that are working for departments of the government like the Department of Homeland Security. I have to put a plug in here for my favorite retired former Michigan Senator Carl Levin. That's his picture on the bottom. Senators and representatives and our president, they are all civil service employees. Now, there are two types of defined benefit or pension retirement plans that federal employees may be a member of. The first one is the Federal Employees Retirement System, which we're going to call the FERS plan, and the other one is the Civil Service Retirement System. So the Civil Service Retirement System is CSRS. Again, they are not subject to division via Quadro. Quadros don't work. What they are subject to division via is a court order acceptable for processing, or we'll just refer to it as a COPE. And there are three sections that need to be addressed. One is the employee annuity, which is the pension. Two, a refund of employee contributions. And three, the former spouse survivor annuity. So you don't need to worry about that too much. I'm going to get into some detail on that. What you need to take away from this is that there are two different defined benefit plans for civil service employees, and they have some very different rules. So that's one heads up or warning. So again, there are three parts to the court order acceptable for processing. One is the pension and the description of how that pension income is going to be divided. And we're going to go through some formulas in a little bit. Also, refund of employee contributions must be addressed. There is an ability for the employee, the civil service member, to request a refund of all the contributions that they have made, which will eliminate their pension benefits, which will eliminate the pension benefits for their former spouse. Because the former spouse, they won't automatically get a share of the refund, and they certainly aren't able to make that decision. But the court order acceptable for processing, the COPE, can address that by barring the employee from requesting the refund of employee contributions, or by putting a note in there that if the employee does request a refund, that the contributions will be split, the lump sum split between the parties. The third area is the former spouse survivor annuity, and that's what happens when the member dies. And the way that I like to explain it when I'm talking to attorneys about what is the pension benefit, even in a corporate plan, and what is the survivor benefit, the pension benefit is that monthly income that's going to be received while the employee is living. Once the employee passes away, that benefit, think of it as being completely gone. It's not there anymore. Only if there is a survivor benefit in place, which is pretty much like a life insurance policy, will any payments continue to any surviving spouse. So we need to address those in two different areas, just like in a regular Quadro. So the first plan, the FERS employees, those are the employees that are newer. If they were hired after 1984, they automatically go into the FERS plan. The most important thing that you should remember and take away from this is that FERS employees are entitled to receive Social Security benefits, whereas the CSRS employees are not, and that is really significantly important, and I'm going to touch a little bit on why that matters. So again, FERS employees are entitled to receive Social Security. The CSRS employees are not. They are also able to participate in the Thrift Savings Plan, which is like a 401k plan that the federal employees have. It's very similar to the 401k plan in a private sector. A couple differences, different from the private sector plans that you would submit a Quadro on. You cannot get a pre-approval from the government. You send it in. If it's rejected, they send it back rejected, and then you try again. So they will not pre-approve, like is different again from most most pension plan administrators under ERISA will provide that service. There does need to be a new designation of beneficiary form completed in addition to the division order. So that's another form that you would need to make sure your client had if they were going to be the one receiving, or if they were the owner of the plan, so that they could name a new spouse beneficiary. It won't automatically change after the divorce. Different, again, than a corporate plan, a private sector plan. You have to mention earnings and losses or they will be ignored in the order, and you don't need to mention loan balances unless they're going to be excluded. So there's just a few little things you need to remember. Again, nobody would expect you to remember this. What you should do after this session is go back, print out my slides, and so that you have this handy when questions come up, keeping in mind that it changes constantly. So the first, employee survivor benefits. Again, that's the benefit that is going to continue when the employee is deceased. So the pension benefit is gone. And the first survivor benefits are different than the CSRS survivor benefits. So I'm going to walk you through this, but again, this isn't one of those things that you need to have full brain power on. I'm going to let you know when those come up. This is just showing you that there are some differences. So there are 3 choices. For survivor benefits, there are full survivor benefits, which give 50% of the employee annuity amount. And I'm going to give you a monetary example to make so that makes sense. And then you also can have a reduced survivor benefit of 25%. The full survivor benefit gives 50% again to the survivor. It costs a 10% reduction in the pension that's being paid while both parties are living, whereas the 25% amount to the survivor costs a 5% reduction in the first pension. So obviously you're going to take a little bit more of a hit in your monthly benefits to give a larger benefit to the surviving spouse. So if you look over on the right-hand side of the screen in the big yellow box, let's say we have a $2,000 a month employee annuity or pension, and again, this is while the employee is living. So the full maximum amount that can go to any survivor, whether it's spouse 1, 2, 3, the full amount that they can give to anyone is 50% of the pension. So the full amount is going to be $1,000 a month to the surviving spouse, and that, so I'm not sure if I'm making that clear. The full amount to the survivor, the reduced amount, if you look on the left-hand side, with that you're going to get a 5% reduction in the pension benefit. The reduced amount is $500 a month. And then, of course, there's none. So let's say that you're working with the former spouse, and they're anticipating that they're going to be receiving $1,000 a month. Let's say they're getting 50% of the employee annuity for the rest of their life. As long as they get full survivor benefits, they will. However, if they are getting a reduced survivor benefit, they might be surprised to find out that their $1,000 a month that they were planning on to live and pay their mortgage has now dropped to $500 a month. And of course, these numbers are different as they're going to be different as the employee continues to work and earn more of their own benefits that are not subject to division. So this is, again, really important to remember, and that's why this needs to be specified in the COPE and as far as what amount the survivor benefits are going to get. So if you've got a client that comes to you and they have a COPE and it's already been entered, and you look at it and you see that it says it's a reduced amount of survivor benefit instead of a full amount, now you know what that means, and you might want to see if there's something different that can be done about that. That's one of those let's put the toothpaste back in the tube if we can moments. Now, the most important thing, this is one of the things that you want to have your brain power on, the CSRS employees are not entitled to receive Social Security benefits. So they don't pay into Social Security and they don't receive any Social Security benefits. So what are the implications of this on divorce? They're pretty significant. It can be argued that there is a phantom Social Security component of the CSRS benefits. In other words, their pension, some people say, is artificially increased to account for the fact that they are not getting Social Security. And so there is a phantom component that needs to be taken into consideration. So if you have one party in a divorce working in the private sector, paying into Social Security, they're going to get that Social Security amount. The other side getting the CSRS benefit, if they are a civil service employee, they are not going to be receiving even a spousal benefit, a spousal Social Security benefit in most cases. So most likely, again, there are no spousal benefits for CSRS employees due to the government pension offset, and there's a formula that you can figure out, am I really going to be entitled to it? I can tell you without even going through the numbers, I've yet to find a case where somebody was entitled to the spousal benefit. It's such a restrictive formula. And remember, the CSRS employees are the ones who've been there longer. So if you have somebody that comes to you and they have been with the civil service for a long time, most likely they're going to be receiving the CSRS pension benefits. One interesting thing to note is that interesting and strange, that the CSRS employee survivor benefits, where did that slide go? Here it is. CSRS employee survivor benefits, they have to be awarded some part of the survivor benefits, well, the full amount or the reduced amount, in order for the former spouse to maintain their health insurance benefits through the civil service. So that's, again, something that should be discussed. If the former spouse of the employee doesn't have health insurance and they decide that they're going to forego any pension benefits or any survivor benefits, they have to receive some portion of the survivor benefits in order to maintain their health insurance benefits. So that's a strange, unexpected trap. I wanted to warn you also that in some of my slides, my children thought they were a little bit, they needed to be jazzed up a little bit, so there's going to be a few little areas where you will see some of the things that my children put in to jazz it up, and I won't need to point them out. You'll be able to spot them, and here's one of them. So some important traps to remember with CSRS and FERS. This is really important. If the former spouse remarries before age 55, the former spouse loses all pension benefits and survivor benefits. I'm going to say that again because it's still shocking to me. If the former spouse, again, remarries before age 55, the former spouse loses all portion of the pension benefits that were assigned in the COPE and awarded in the divorce, and all survivor benefits. And that is the federal law, and that can't be changed by the state court. So again, this is really important. If you've got a client that is almost 55, you might want, and they want to get remarried, you might want to counsel them to get remarried at 55 in one day so they don't lose all their benefits. And imagine their surprise as if they've been working with you as a divorce financial specialist and you didn't warn them about that. So again, nobody expects you to remember the exact age, but what you do need to remember is that there is an age that if the former spouse remarries before, they will be losing or waiving their right to all of the pension benefits and survivor benefits. Okay, and other things to be aware of, again, there should be a barring of that refund of contributions. And so just as a reminder, there are 3 sections of the COPE. The first addresses the employee annuity, the second addresses the refund of contributions, and the third addresses survivor benefits. So that COPE order, if you're working with the alternate payee, and in all sense of fairness, even if you're working with the employee, there should be a provision in there that bars the refund of the employee contributions, which in effect completely eliminates the pension benefit. Or if the parties are okay with getting a lump sum instead, that in the future, that at least the refund is split between the parties. But without that provision in there, that's scary for the alternate payee. There's another one of my kids' emojis. Okay, there are 2 basic methods, and I'm going to back up just a little bit here. We're going to talk a little bit about the QDRO provisions. So we're turning off all information for this second about military civil service plans. We're going to go back and we're going to talk about QDRO provisions for ERISA plans, because you really need to understand a few basic things in order to compare and contrast with civil service and military benefits. So there's 2 basic methods to divide up corporate or private sector pensions. There is the separate interest method and the shared benefit method. These 2 methods are available for every private sector pension plan, whether or not the company gives you a model, a QDRO model that shows a model for both methods. They are both they're both you're eligible to use both for any private sector pension plan. And I shamelessly stole this idea from Ed Schilling, who used to do a lot of work with the IDFA. He's a lawyer based in Colorado, and I love the way he explained the difference between separate interest and shared benefit because it's easy to understand. He had been basically the plan administrator for the Air Force and realized that the lawyers that were submitting orders didn't know what they were doing, and that he could have a good business by leaving the Air Force and starting his own order drafting business. So he was very successful. And brilliant. So his idea, again, that I'm stealing from him, is that the separate interest approach, think of it as if it's two boats. So think of the retiree and the alternate payee, who's the non-employee spouse, starting down the retirement river. They're going to jump into two separate boats before they take their journey down the retirement river. Now that means that the alternate payee can jump into his or her boat at the participant's earliest retirement age, whether the participant jumps into his or her boat or not. So for those cases that you have where the employee is saying, my ex is never going to get 1 penny of my pension, I'm just never going to retire. The way to avoid that problem is the separate interest approach is used. And again, I want to remind you, we are talking about private sector quadroable plans. Under the two-boat method also, once the alternate payee jumps into his or her boat and takes their journey down the retirement river, the company actuarially adjusts the benefit for the life expectancy of the alternate payee. So let's say that there's a greater than 10-year age difference between the parties. What that means is that there might be a significant reduction in the pension benefits for the alternate payee by using this method that may or may not be desirable. Also, before the alternate payee jumps into his or her boat, waiting on the dock, there needs to be pre-retirement survivor benefits in place to secure their benefit before they jump into the boat. Again, the pension benefit is going to stop or cease completely once the employee dies, and only if there's a survivor benefit in place will anything continue. One way around this is using the separate interest method. So although the former spouse needs to have pre-retirement survivor benefits in place before they jump in the boat, once they jump into their boat, they don't have to worry a bit about the participant passing away before them. Their benefits they're going to continue down that river. They're going to wave goodbye as the other boat capsizes with hopefully not a smile on their face, but they will never lose their benefit amount. It's always based on their own life expectancy. So that's the separate interest method. Now the one boat method is also the shared benefit method, or the sharing method you'll see. In this method, there's only one boat. The alternate payee cannot jump into the back of his or her boat and go down the retirement river until the participant jumps into the front of the boat. Their benefits are always going to be tied together. They're always going to be based on the joint life expectancies, therefore, of the parties. And you need pre- and post-retirement survivor benefits in place to secure the alternate payee's interest. So before the alternate payee is, while they're standing on the dock, before they jump into their boat, they need survivor benefits to protect them. After they jump into the boat, they need survivor benefits to protect them. One other thing to remember is if they're in the back of the boat, the alternate payee, and they pass away, they die before the participant, their benefits on the shared benefit method in the one boat pop back up to the front of the boat to the participant. So if, let's say spouse number one was getting $1,000 a month, the participant was getting $1,500, if she predeceases him, her $1,000 a month goes back to him. So now it's worth $2,500 a month. Now, this is the only asset that I know of in a marital estate where when one person dies after the property settlement is done, that asset goes back to the former spouse. So if I get the house in my divorce and I die before my ex-spouse, it doesn't go back to him unless, of course, we have some titling issues. But this is the only asset that I know of that works this way. In the separate interest method, if the alternate payee dies prior to the participant and he or she has already jumped into their boat, only if they've named a future surviving spouse does anything happen to that payment. Otherwise, it goes back to the company. So there are definitely, you can see already that way I've set it up for you, there are lots of arguments and negotiations that can be made while you're negotiating divorce with private sector pensions, and that can really make a big difference in people's lives and are a great negotiation point. And I'm going to be talking about that at the IDFA conference as one of the things for private sector plans. If you're going to be in Orlando, come and stop by my presentation and you'll be able to hear that information. Now, let's get away from private sector plans and we're going to go back, still on the civil service. The CSRS and FERS plans, you can only use the shared benefit method. The one boat method is all that is available to you. That means the alternate payee cannot commence benefits until the participant does. Benefits are based on the joint life expectancy of the parties. We need to have pre- and post-retirement survivor benefits in place to secure the alternate payee's interest. And if the alternate payee dies before the participant, the benefit amount they were receiving bumps to the front of the boat and goes back to the participant. This is not negotiable. The federal statute that gives Congress the authority to divide up, that Congress gave to the Department, the DFAS, sorry, the Office of Personnel Management, that's their rule. It doesn't matter what the state court says. If your judgment of divorce says alternate payee can begin at the earliest date possible, it really doesn't matter because the federal law is always going to trump state law. And so it's important to know that what the actual federal law is in this case, and it's always going to be one boat. So here's a question for you to ponder, maybe think about for extra bonus points. An advanced planning question. Let's say you've got one person in the private sector and one party in the public sector. Knowing that the civil service pensions can only be divided with the shared benefit approach, is it fair to negotiate that the other person, the person in the private sector plan, that their pension benefits should also be forced to be divided in the shared benefit method? I don't know what the answer to that is. I think it's worth a discussion, certainly, and it's definitely worth knowing that there's a restriction on one person's benefit division, but there's not a restriction on the others if one is in the private sector. So this is something to think about and discuss with your clients. Okay, now we're going to go back again to private pensions that are allowed under ERISA, and I know that this might be the most confusing piece of my whole presentation here. So I'm going to try to make it simple, and I'm going to, after I go through and explain it, I'm going to tell you what the bottom line is. What does it make a difference? So there are two different ways that you can divide up any pension using a coverture fraction. One is called the accrued coverture. The other one is the prospective coverture. So basically, before I go through the formula, in the accrued coverture method, the benefit amount is cut off as of the party's date of divorce. So whatever the participant accrues after the date of divorce, the alternate payee doesn't get any portion of, not any share of, with the accrued coverture method. In the prospective coverture method, the division date becomes the date of retirement. Now, that doesn't mean that the alternate payee is entitled to 50% of the entire pension as of the date of retirement. What it means is that they're entitled to a portion of the increase. And the theory behind that is, as you work and you earn pension benefits, your pension really escalates, let's say, the last 5 years of your employment. Well, if you've been married to someone for 20 years and the last 5 years of their employment, you're not married to them, didn't it take the early years to get to the later years, and is it really fair or equitable to have that division date be the date of divorce? So here's the messy formula. Accrued coverture, it's going to be some percentage, it could be 50%, it doesn't have to be 50%, times the benefit amount accrued on the date of divorce, times the fraction. The numerator is the number of months of credited service earned during the marriage. The denominator is the number of months of credited service earned as of the date of divorce. And I know that probably sounds like blah, 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 blah. What you need to remember and notice here is that the division date in the formula is the date of divorce, whereas in the prospective coverture, the division date, the key words that should pop out at you there are the date of retirement and in both sections of the formula. So we're getting a little bit more benefit to the alternate payee by using the prospective coverture, and that's all you really need to know. You also need to know, even for your clients that are in private sector plans, that there is a difference here, a slight difference in the wording that might look like, oh yeah, that's standard boilerplate language, that's fine, but there is that slight difference, and so you need to know when you're reviewing a judgment for a client of divorce that if there is specific language, that you make sure that the client understands what that is. Okay, and here's an example. You can see the bottom line. The accrued coverture fraction in this particular case with a $2,000 a month lifetime benefit, the alternate payee would get $500 a month, whereas using the prospective coverture with the same pension, actually, I have to see, I've got a mathematical error in there. So I won't go back to that page. I will correct that before I give the link to Brittany. But the prospective coverture actually is going to give slightly more money to the alternate payee. And depending on how the pension is calculated and the circumstances of your case, it could be a significant dollar amount or it could be a small dollar amount. So of course, now we're going to put private sector plans away. We're coming back to the public sector plans. With the civil service plans, the only method available is the prospective coverture. So there's no point in arguing it. This is all they allow. They only allow that you're going to divide up that pension as of the date of retirement, regardless of what the judgment of divorce says. And if a COPE is submitted with different language, it just gets rejected. So here's another thinking question for you for extra points while you're negotiating cases. If one person's in the private sector and the other party has a civil service plan, should they both be divided using the prospective coverture if one's corporate and the other is civil service? Or are we okay with one being divided prospective coverture and another one being divided accrued coverture? So something to think about. There is no one answer. And again, that whole topic might be the most complicated of the features, but all you need to really walk away remembering is that, and based on the wording, the language in the settlement agreement or the judgment of divorce, there's either going to be a cutoff on the date of division or the date of retirement, and for civil service employees, it has to be the date of retirement. So next, who holds the information we need? The Office of Personnel Management handles pension plan administration, and that's who should be subpoenaed. If you're working with attorneys, that's where the requests go. Now, there's an agency that handles all the employee information until retirement that is a different place. So if you look at their website for OPM, you'll see that there are different places to send subpoenas to. Another thing to keep in mind for civil service cases, once the participant has died, you cannot enter a post-death order. This is actually not the case anymore with private sector plans. This is the only change that I know of actually in private sector plans that is significant since 1984, when the Retirement Equity Act started to allow for the division of, when ERISA started to allow for the division of private pensions. Okay, so now I'm coming to the really fun stuff, and I don't say that sarcastically. To me, this is the fun stuff because it's brand new. So if you've got, we're going to put away civil service employees. Now we're talking about members of the military. So you've got one party of the divorce who is in the Army, Navy, Marines, Air Force, or Coast Guard, either in active duty or reserve duty. That's who the rest of the presentation is going to be about. If you're confused about dividing military pensions pursuant to a divorce, you are not alone. There are so many loopholes. Working with attorneys to negotiate a fair settlement for your client is like walking through a minefield. Plus, as I mentioned in the beginning, the rules are constantly in flux. In 1981, the U.S. Supreme Court ruled that the former spouse of a military member or retiree could not be awarded a share of their military pension. That case was called McCarty versus McCarty. So in another example of our separation of powers doctrine at work, Congress overruled the Supreme Court decision, and they said no. In 1982, the Uniformed Services Former Spouses Protection Act was passed as a response, and it did allow for the division of military pensions in divorce, which obviously, from my perspective, and probably all of you listening, is fair and equitable because it's probably the largest asset that a couple may have if one person is in the military. So as you can probably imagine, there are certain contingencies that are still opposed to this law. Some feel it's unfair to service members. On the other hand, some feel it doesn't go far enough to protect former spouses. This presentation that I put together today, this part of it, relied heavily on federal resources, including a congressional research report that was published just in March 2017 by the Congressional Research Service. So this is the most up-to-date information, and since I've been presenting on the military, these things have changed significantly over time. There was a major change in 1991 and a major change in 2001, so it's really important to keep up on these. And there are some major changes coming down the pike for 2018, which I'm not covering in this presentation. Okay, so dividing military retired pay. What you need to know is that for property division, not when we're talking about for provisions of alimony or child support, just for property division, in order to directly divide with an order the military retired pay, there has to be 10 years of service that the military member had that overlaps with 10 years of marriage. Not everyone falls into that category. It used to be that was the only way that the former spouse could receive any benefit. So only if they've met that 10 and 10 rule. I can't tell you how many people call our office. In fact, I think that we just got some calls last week, people that thought they were going to be able to get part of the pension, the military pension, but they did not qualify under the 10 and 10 rule to get the pension directly from the federal government. Now, this law nowadays only affects how a military former spouse receives it, how they receive it, not if they receive it. So this is important to remember. The state court can still award a portion of retired pay in any manner that's congruent with state law. So they can still get a part of the pension, it's just not going to come directly from the federal government, which means everybody's got to go back to court if they haven't anticipated this. The maximum award for the disposable retired pay that can go to an alternate payee is 50%, whether there's one former spouse, two former spouses. The maximum amount that can be awarded is 50% of disposable retired pay, which I'm going to talk about in a second and explain what that is. That is very different than private sector plans. Under the ERISA rules, you can award up to 100% of the pension benefit to the alternate payee. A lot of times I hear attorneys say that they're going to quadro a pension and they think that means they're going to 50-50 it. But it doesn't necessarily mean that. You can award 10% of a pension. You can award 100% of the pension. For the military members, you can only award, the maximum award is 50% of disposable retired pay. Now, if there are provisions already set aside for alimony and child support, then that amount goes up to 65%. And let's say that there's more than one spouse, former spouse. How does that work? It works on a first come, first served basis. First divorced spouse, if they get the full 50%, divorced spouse number 2 is going to get nothing, even if they qualify under the 10 and 10 rule. If there's still a little bit left, let's say that there was a reduced award, again, the maximum amount is going to be 50% of disposable retired pay. So what is all of this about disposable retired pay? That's something different about the military. This applies for divorces. This is the most current rule that have occurred after 1991. This rule is still in effect. So what we're looking at is the pension benefit. They take that full amount. So in this case, let's say that we have a $2,000 total monthly retired pay benefit that's going to the military member. Let's say that she's in the Air Force and she's going to receive $2,000 a month when she retires. Now, we said that 50% of the benefit could go to a former spouse, but it doesn't mean 50% of her total pay. So it's not going to be a maximum of $1,000 that can go to the former spouse. And first we have to take off some deductions. So the deductions that are allowable are amounts owed to the U.S. government for overpayments, forfeitures ordered by court-martial, military disability pay, VA disability pay amounts waived pursuant to Title 38 of U.S. Code, and the Survivor Benefit Plan premium. So that's a lot of different things that are going to come right off the top that if you get an estimate from the military from DFAS where you're trying to find out what is the retired pay that the is eligible to receive, keep in mind that half of that is not going to be a former spouse. It's only going to be half of the disposable retired pay, which, as you can see here, is a little tricky for you to figure out. So in this case, there was a survivor benefit plan deduction of $200 a month, so disposable retired pay goes down to $1,800. Each receives $900 per month. Now, but remember that there are some benefits that the participant or the military member receives that are going to offset for the reduction, whereas the former spouse is not going to receive any of those additional benefits. And I'm going to explain that in a few minutes. Okay, survivor benefit election coverage. This must be, and again, the maximum amount that can be awarded is 50% of the pension. Has to be sent, the survivor benefit forms need to be sent to a different address than you're sending for the disposable retired pay division. So we've got pension division orders going to one address. The survivor benefit forms going to a different address. How can you help? Why does that matter to you as the CDFA? Well, if your client is worried that everything hasn't been entered, you know that it needs to go to two different addresses, two different places, and you can help make sure that that's been handled and done. There needs to be a deemed election of the former spouse coverage, another form that needs to be filled out. That form can only be filled out by the member, and no one, the alternate payee or the state court judge, can't force them to sign it. So it's one of those forms that it's helpful for you to have for your clients entered simultaneously with the judgment of divorce when the parties still have a reason to be amicable. After the divorce is over, there's certainly going to be less cooperation between the parties. The new rule, there's a new rule that was effective in January of this year, and I'm going to talk about that significantly going forward. But one of the new provisions is that a military member can now provide survivor benefit to a subsequent spouse, but only if the former spouse dies. So if they get remarried and they've given 50% of their survivor benefit has already been awarded to spouse number one, only if spouse number one dies are they eligible to give it to someone else. This is a change. It used to be that they weren't able to give it to anyone at all, even if the former spouse predeceased the member. So that is a new change that is part of that new law. And going back to the whole one boat, two boat method, I'm not going to go through this again. If you've printed out the slides, you can go back and take a look. This is the same theory that we were talking about with private sector plans that can use either separate interest or shared benefit versus the civil service plans, which can only use the one boat method. And you guessed it, the military only allows the one boat method. So again, important for you to remember and keep in mind. So a couple things to remember. One thing that's going to be important is to make sure that the member provides their points record to the former spouse. Again, that's something that should be done during the discovery process. And if you're involved in a case where that hasn't been done, you're going to want to bring that up to the attorneys that you work with. Another thing to keep in mind is that DFAS forms have to be used in addition to the court order. So the court order is not sufficient. The DFAS forms have to be used as well, and they have to be signed by the service member. It doesn't matter if the former spouse signs it. It doesn't matter if the judge signs it. It needs to be signed specifically by the service member. So this is really a matter of crossing the T's and dotting the I's. The big news here is that the National Defense Authorization Act for fiscal year 2017 that became effective and was signed into law by President Obama on December 23rd, 2016. And it made a significant change to the way that military pensions are divided, and yet it was one of those things that was tacked on to the end of a bill that had a lot of other information, and I don't think that there was a clear understanding of how this is changing things for former spouses and military members going forward. And it's but now you all know it, so you'll be able to show any of the attorneys that you work with how up you are on all the newest laws. So the National Defense Authorization Act states, and I'm going to go back and review that, let's see. Oh, there's my fancy slide from my kids. Okay, so remember we talked about the accrued versus prospective coverture, whether or not the division date for the pension is going to be the date of divorce or the date of retirement. The longer the employee works for the company, the more that matters. And that's what you need to remember for that. And I told you that with civil service plans, the only method is the prospective coverture. So there's always going to be a slight bump up or a large bump up for the alternate payee when you're dividing a civil service plan, because they are going to be entitled to a portion of future accruals. With the military, that used to be the rule as well. The rule used to be that you could only use the prospective coverture fraction. Well, the new law that became effective in January of 2017 says, nope, they all must be divided as the date of divorce. You are not allowed anymore to award any benefits to a former spouse that accrue after the date of divorce at all. And so that whole argument about it takes the early years to get to the later years, is it fair and equitable to cut out the former spouse from the real bump up in the pension benefits, or portion of them, just because they are divorced right before that happens. That argument's been taken away by the new law, and now the accrued coverture fraction is the only method of division available. So again, that thinking extra points question is, should both pensions be divided using the accrued coverture if one is a private sector plan or a civil service plan, sorry, a corporate plan, and the other is a military pension plan? So again, should both pensions be divided using the same division method if one is required to use the same division method? And the answer to that, I don't know, it's maybe, maybe not. I guarantee you nobody is discussing it and negotiating it while the divorce is pending, but it's something that should be considered. Okay, trap here. If the former spouse remarries before age 55, the former spouse loses all survivor benefits unless the subsequent marriage is terminated before he or she reaches age 55. And that's sort of an old-fashioned idea that when it used to be primarily assumed that the wife is the one that's going to be receiving survivor benefits, when she gets remarried, there's some other man to take care of her financially, and so that's the reason for this somewhat, I wouldn't say somewhat, this antiquated rule. But this rule is still in place. This is a little bit different than the civil service pension rule. It's a little bit better. The former spouse still gets to receive pension benefits up until the military member's death, but they would lose survivor benefits, whereas under civil service plans, they lose both their share to pension benefits and survivor benefits if they remarry before the age of 55. 55 in one day, they're all clear. Okay, a few more points here. This is the most dangerous trap that you need to be aware of, and I put it last just to make sure that if anybody was kind of lulled to sleep by this presentation, this is the time to wake up and take out a notepad and write this down. So disability benefits are not transferable. If you are a military member and you qualify for disability benefits, those cannot be divided with any order. And if you transfer if you elect disability benefits, there are two ways that you can elect them, either under the VA or qualify for full disability. You can waive your pension benefits and have instead it become a disability benefit. So let's say John and Mary are married. They've been married for 25 years. They get divorced. John decides to turn his pension into a disability pension. He qualifies for disability under the VA, not because he can't work, but because he meets certain requirements, whether it be emotional or other things that impair his ability to work. He transfers to a disability pension. Jane's expecting to get her 50% of the pension benefits when he reaches retirement age, and then he retires, and she says, where's my money? And there isn't any money because you can't divide up the disability payments, and John waived the pension in lieu of getting the disability benefits. So, and you cannot bar someone from electing disability benefits in lieu of this. There isn't anything you can put in the official order that, that bars them from electing this, but you could put something in your settlement agreement and your judgment of divorce that anticipates something like this and determines what can we do instead. If this happens, then how do we get that money? Without that in the settlement agreement, it's going to be really difficult to get. The other big thing to avoid is the waiver for other federal retirement plans. If you are a civil service employee, so like after the Gulf War, we really downsized our military and started, many more people started switching over to civil service jobs. So there are many employees that have both military pensions and civil service pensions. They have the option when they retire, they have three options. One, they can elect to receive both, their civil service pension, CSRS or FERS, and their military pension. That's one option. The second option is they can waive their military retired pay and Social Security and just get the civil service pension. And that's another choice they can make. The third option is to do the above, but add a lump sum of money to a department of the government to be able to continue to receive Social Security benefits. So again, there's three things that they can choose, the military member. Guess who the choice is up to? Not the former spouse. There's nothing that the former spouse can do to prevent this from happening. So if they elect to receive both, and the member does, and you've got a court order for both, that's not a problem. If they elect to waive their military retired pay, and in lieu of that take more of the civil service pay, are you going to be able to award any portion of that civil service pay that used to be military pay to the former spouse? That's going to be a big can of worms to go back and try to work on. As far as adding a lump sum, again, that decision is completely up to the military member. And as I mentioned before, Social Security is a tricky issue. There's something that the new law, there's something called Catch 62. The Catch 62 says that you're allowed to put that lump sum in to be able to allow yourself to continue to get Social Security and military retired pay, but you have to add that money to there, that the ability to add the money.
Jack,
so, oh, yeah.
Sorry to.
I'm done, right?
No, I wanted to get to some of these questions, so
okay.
If you need a couple minutes just to kind of wrap up,
yep.
Just let me know when you are all finished.
Okay, I am ready to wrap up. So we come right to the end. What you need to remember walking away from this. Your head might be spinning trying to remember all of these rules. What you need to know is that there are differences between private and public sector pension plans. And if you know that, you know a lot more than many people working in the divorce arena already. And then you would know where to go to look for information. You need to be aware of the pitfalls, traps, and loopholes, like remarriage before age 55, refund of contributions, disability issues. But mostly what you really need to know is that there are a lot of rules and that they change pretty often. So if you want to connect with me on LinkedIn, you can look for me. I always, when I update my blog, I always put a notice there, and I write blogs about the new changes as they come about. So thank you for listening, and that's the end of my presentation.
All right, thank you so much, Jackie. Okay, so there are a ton of questions, and obviously, guys, I'm really sorry, but we're most likely not going to be able to get to all of them. But again, any that we did not get to, we will, as Jackie mentioned, you can connect with her on LinkedIn. I will make sure that you have her contact information in the follow-up email, and I will send her any of these unanswered questions after the presentation as well. So this first one here is, what is the difference between a high 1 and a high 3? I'm working on qualifying military court order, and the member says his benefit is based on a high 1, but we cannot find any information about this.
I'm not sure. That would be a question that I would have to look up. I don't know. That's a good question.
Well,
I'm writing it down, and it's something that I can look up. I know where to go to look it up, and the place that you would go to look it up is in the DFAS guidelines, which you can find online. They're a little confusing to look through, but that's where I'm going to go to look it up, and I'm not sure of the answer.
All right. Well, that is
Okay,
okay.
Brittany, give me an easier one.
Okay. Well, here's one. If the rules change all the time, where can we go to find the most up-to-date info?
The place that I would go is directly to Congress, actually, to all of their records online, because they have, all of it is done with congressional approval. The other thing to keep in mind is that rules change. I don't know if I mentioned this, but they're never retroactive, ever. So that is something to keep in mind depending on when the parties got divorced. Another place to, I mean, it might be a good idea for a future blog, actually, is a listing of all of the rules that have changed up to the current ones. And like I said, there are some big changes coming for the Thrift Savings Plan that are coming down the pike in 2018. And so there are going to be changes that I know of for sure, and there are other ones that are currently being debated. So, so definitely keeping up on the changes is an important piece.
Okay. Oh, where'd it go? Oh, there we are. Okay, and so we have a bit of I guess a scenario here from Kim. She says, in my divorce, my ex is retired military, and we had to have a quadro to split his pension and also a quadro for the TSP as well. How can you say that a quadro was not necessary for the military pension?
Okay, so you didn't have a quadro on the military pension. You had a different document. A quadro doesn't work because quadros only cover private sector plans, Kim, and they fall under very strict rules under ERISA, the Employee Retirement Income Security Act, and those same rules do not apply for military pensions. As far as the Thrift Savings Plan, yes, they do accept a quadro on that. It's like the 401k type plan, the defined contribution plan. If you put the words quadro on the top of it, they will accept it. As far as that being true for the military, they will not. And again, the rules, like my presentation showed, are dramatically different between the private sector plans and the public sector plans.
Okay. From Steve, we have, is the loss if married before age 55 for both CSRS and FERS?
Yes.
All right. From Catherine, we have, if a former spouse remarries and losing pension benefits awarded to them, does that revert back to the employee?
Yes.
Perfect.
Not perfect for the former spouse, but
no, definitely not. Let's see here. From John, we have, what are pre-retirement survivor benefits?
Okay. Pre-retirement survivor benefits are when I talked about the one boat, two boat, when the alternate payee is standing on the docks, in other words, before the participant retires, before they start receiving any benefits, you have to have pre-retirement survivor benefits in place in order to ensure that payments continue after the death of the employee. So if the employee dies before anyone gets any money out of the pension, if there isn't a pre-retirement survivor benefit in place, the former spouse won't get anything.
Okay, thank you for that. It looks like we have I'm going to do just a couple more questions. Let's see here. How do you secure pre and post survivor benefits?
The only way to secure them in a private sector plan is with a quadro. That is the only way. The only way to secure them in a military plan or in a civil service plan is with the appropriate court order. So in other words, once the divorce is done and everybody walks out of the courthouse, the participant can go and change their beneficiaries. There's nothing, the federal law says as long as they're not married, their former spouse doesn't have to waive their right to that. If they are married, they have to have their former spouse sign off on it, or their current spouse, sorry, sign off on it. The only thing that protects the former spouse with survivor benefits pre and post is actually going to be the quadro or the military order. That is the only thing that's going to protect that alternate payee. Not even the judgment of divorce is going to make a difference.
All right, and last one here, I do, just as a, oh no, okay, last question, really quick, we have, what is CSRDF?
Oh, I knew somebody was going to ask me that. Somebody noticed that I just skimmed by that. I have it written down. What is, let's see. It's the well, what it is it's the place that you can put your money, your the Catch 62 money into. And let's see. No, this just says civil service. Civil service, retirement, something. I don't see it on here.
That's okay. I will add this question into the list that I send you. And someone did ask if we can compile all the questions and send them all the unanswered questions and your answers out to everyone by email, and we definitely can do that. So
I found it.
Okay,
I found it. Civil Service Retirement and Disability Fund.
All right, Madeline, hopefully that answers that for you. Okay, so again, we have a ton of unanswered questions. I will get those to Jackie and get her answers. She's going to be sending me her slides. So in the follow-up email that I send out, hopefully tomorrow, it may be the day after, it will have a link to the presentation so you can rewatch it all over again. It will have a link to her slides, her contact information, and if I can get all of, Jackie, I'm going to give you some time to answer all these questions. So these question and answers may have to be pushed until next week, but I'll definitely get them out to everyone.
Okay, sounds good. Thank you for giving me a little time.
Oh, not a problem. It's going to be a big one. And again, thank you, Jackie. Thank you so much for giving us this presentation, and thank you to all of you on the line for joining us. All right. We will see you next month, and keep an eye on your email, okay? Have a fantastic rest of your afternoon.